Argued from court. Professor Griffin joined the Duke Law faculty in 2008 after serving as a federal prosecutor in the Chicago U.S. Attorney's Office, and focuses her scholarship on criminal and absolutely amazing panel set up for the justice policy journals with you today to the Supreme Court on an evidentiary in 2000. Rosemary, the case June 23rd. Advisor J.D.B. North Carolina for Judge
and along break.
I'm very excited for Blocher.
I think in the larceny.
Opportunity to introduce Ms. Barbara Blackman. Ms. Blackman is a counsel of record for J.D.B. and actually argued the case before the court 2 weeks ago. She has extensive experience in civil and criminal appeals, from serving as the chief appellate deputy with the Colorado State Public Defender in the Capital Post-Conviction Unit of the Indiana State Public Defender, and most recently the assistant appellate defender with the North Carolina Office of the Appellate Defender. She has litigated appeals in the Colorado Supreme Court, the Indiana Supreme Court, the North Carolina Supreme Court, the 10th Circuit Court of Appeals, and the U.S. Supreme Court. Second, allow me to introduce our very own Professor Griffin. After graduating from Stanford Law School, Professor Griffin clerked for both Judge Dorothy Nelson of the 9th Circuit Court of Appeals and Professor Blocher of the Second Circuit has worked
and his
to Sandra Day of the
appeals counsel, I guess the time was
of the United States.
And he confessed to taking the camera, said that the other boy had stolen a cell phone, and blamed the other boy for planning the break-ins. He goes on to discuss the details of the Blackman trial. Break-ins, the officer tries to ask him to write down those details, which he does. They make him promise never to do such a bad thing again, which he does, and then they send him off to catch the bus and go home. So this whole thing, I think, gets 45 evidence test on the basis that
District of Columbia
he was never Mirandized. He was in custody, in other words, and he was never read his rights. So in order to win on that, of course, the counsel needed to prove that J.D.B. actually was in custody, and part of the argument that he or she made was that he's 13 years old, and he was taken into this conference room by police officers at school, and of course he didn't reasonably feel that he was free to leave. And that's where the hard constitutional question is, right? I mean, the reasonable, what a reasonable person would think they're free to leave, like I said, it's hard in any case, but when you're a 13-year-old taken out of class and you're talking to police officers and school administrators in a separate room and not told, at least until midway through, that you can leave, the question may cash out differently. Anyway, this is the argument that counsel made to the trial court. Trial court disagreed, said that, that J.D.B. was not in custody and that the age could not be a factor. The North Carolina Supreme Court eventually agreed in a 4-3 opinion with the trial court, both that he was not in custody and that the age could not factor in. Part of the reason for this is that the custody determination is supposed to be what the Supreme Court has called objective. And if you start introducing things like a person's age or their mental capacity, then you're making it more of a subjective test, and that's what we want to stay away from. So the Supreme Court upholds the trial court ruling, and that's when Ms. Blackman's cert petition comes in. So maybe I'll pass things off.
Oh, okay. I think we have a couple of missing facts.
Oh, okay.
Missing facts.
Flesh it out.
First of all, from the get-go, the police know they're dealing with a 13-year-old. And under North Carolina statutory law, a child under the age of 14 who's subject to a custodial interrogation has to have a parent or guardian present. And the police are made aware very quickly that J.D.B.'s guardian does not want to be involved in this investigation. She feels that he was stopped for racial reasons. So Officer DeCostanza makes a decision, well, then he's going to interrogate J.D.B. at school. It's a very convenient setting for him because obviously the guardian is not going to be there. J.D.B. is escorted out of his class into a conference room. The door is closed. We've got this outside police officer. We have the school resource officer, who is a uniformed police officer, the vice principal, and the intern. And a decision had been made before the interrogation begins that anyone can ask whatever they want. And so that's how you end up with the vice principal interjecting himself into this, telling him basically to confess. J.D.B. makes a number of statements that would be useful against him in a juvenile proceeding, though not directly incriminatory. But then he finally comes up with the, if I give the stuff back, will I still be in trouble, which is pretty directly incriminating. And after that, he is threatened with being placed in juvenile detention facility, and he makes a full confession. At the trial court level, the lawyer argued that not only was there a Miranda violation in this case, but that the statement that J.D.B. gave was involuntary. As the case wended its way through the appeals, it was handled by someone other than me. The voluntariness claim kind of dropped out of the case. And so the only thing that the North Carolina Court of Appeals and the Supreme Court ruled on was the Miranda question. And that's the only thing that's pending before the United States Supreme Court. So the issue that they are going to decide is, is age an objective circumstance? And everybody is in agreement that it is. I mean, the state has conceded it is. They were supported by the Department of Justice, who agreed that it is. But in a way, it has meaning only in its subjective connotations, which is age gives you a certain intelligence level, for example. It gives you certain life experiences. And so it's different in a way from some other objective circumstances. But like any objective circumstance, it has kind of a common meaning, something that we can ascribe to it. So for example, one thing that they look at in custodial interrogations is, was the door open or closed? And if the door to the room was closed, then we think a reasonable person might feel that their freedom of action was curtailed. If you happen to have an extraordinarily claustrophobic person who is just bowled over, by this door being closed, they're not going to get any extra credit for that. They're just going to get that level that we will ascribe the reasonable person's reaction. And I think it's that age works the same way. We have a general understanding of adults versus children, how they interact with other adults, what their general freedom of movement is, and so on. And so how are they going to react when that door is closed? So I think that age can be factored in an objective way. And what the Supreme Court has been doing in the last couple of years is recognizing that juveniles are just so different from adults. Cognitively, they're just not at par with adults. They have limited judgment skills. Their perception of the world is quite different from adults. And the law has never treated juveniles the same way as adults. And so lower courts have been saying, we're not going to treat them as adults in the custodial setting either. We are going to ascribe some meaning to our belief that they will view this interaction with police differently than an adult would view the interaction with police. Starting about 20 years ago, various state courts began looking at this and uniformly said age is a factor that must be considered. And eventually we reached about a third of the state court jurisdictions ruling that. In 2004, out came a case from the United States Supreme Court, Alvarado. It was a habeas case out of the Ninth Circuit, which said the California state court had misapplied federal law by not considering Alvarado's age in deciding if he was in custody. And this was a 17-and-a-half-year-old who was questioned at the police station. So it goes up to the United States Supreme Court as a habeas case where the Supreme Court has to give great deference to the state court's rulings, far different from de novo review. And the United States Supreme Court said, well, we have never once talked about whether age should be considered in custody. So how can we say that this state court was unreasonable in what it did, because it had nothing to follow from us? Oh, and by the way, just as dicta, we're splitting 4-1-4 on this age question. So 4 of the justices said, we don't know about age. We think it might be too subjective. 1, which is Justice O'Connor, said, I can see a case where age would be relevant, but this isn't it. This kid is 17 and a half years old. He's just about an adult. And then 4 justices said, absolutely, this is relevant. If something is relevant, then it has to be considered because it's a totality of the circumstances analysis. And, there's all kinds of reasons why this kid's youth should be taken into account. So after that, the state courts got a little queasy because they didn't know what the United States Supreme Court was going to do. And you saw this minor pulling away by like 2 or 3 jurisdictions saying, well, the Supreme Court's hinting that it might not like it. We don't want to be on the wrong side of this decision. So we're not going to consider age anymore. And then the North Carolina Supreme Court joined in saying, absolutely not. So they're saying there is no case ever that could come up where age would be relevant. I was stunned that the United States Supreme Court took cert, to put it mildly, but they've taken a lot of Miranda cases the last couple of years. They're clearly interested in Miranda. And this is going to be a very significant decision because many states, like North Carolina, have statutes that require parental presence for custodial interrogations. So in all of those states, if age becomes more of a focus than it is now, interrogations are going to be held up by this requirement of getting the parent or guardian there. Ultimately, like for older children, I don't think age is going to make that much difference. Statistically, children waive their Miranda rights about 90% of the time. So, the police are not going to be hampered in that respect from getting confessions. But, it's going to be very interesting. The oral argument was really lively, to say the least. Barely let me get a word in. And the ideological split could not have been more clear. So I think that we've got 1 and maybe 2 players in this case. And that's Justice Kennedy and maybe Chief Justice Roberts. He was a little hard to read, but he's not a big fan of Miranda. So we'll have to see. Justice Kennedy actually authored the part of the Alvarado opinion that said that he wasn't so sure that age should be taken into account. So he's going to have to completely flip his position. And the reason that we're hoping he will split his position is he is the author of 2 penalty juvenile cases, Roper and Graham. One of them holding no death penalty for juveniles, the other holding no life without parole in non-homicide cases for juveniles. So since Alvarado, Kennedy seems to be reassessing juveniles and their culpability and their judgment skills. And so we're hoping that he transfers that knowledge that he used in those opinions into this Miranda question. Obviously, if he stays where he was back at the time of Alvarado, this case will likely come out 5-4. The dissent will be almost the exact same people who were dissenting in Alvarado, and that's going to be the end of this issue. But I think the potential exists that Kennedy will change his mind. Roberts, as I said, I had a hard time reading him in this argument. He actually seemed thoughtful. He, he did seem really to be listening, and he is the justice on the court with the youngest children. So I think he has sort of the most direct experience with children this age, and I think he would best understand that his kids, if in this situation, would not feel that they are free to leave and to tell a police officer that they are not going to talk to. One other fact I forgot to say, which is very important, is that the school rules were that a child must stop when talked to by an adult. A child cannot leave until dismissed by an adult. A child must answer any question posed by an adult. So in addition to just the coercive influence of the questioning itself, there was these outside pressures on J.D.B. to talk. And that is very different from the pressures that would exist on an adult. If we were going to compare J.D.B. being in school to an adult being in his workplace, it's a completely different situation. An adult would not be under any compulsion to talk to a police officer about a matter that did not involve the workplace. And yet here, even though these break-ins didn't have anything whatsoever to do with the school, by school rules, J.D.B. was required to answer questions. And any juvenile investigating officer knows that, and that's one reason why you see this increasing number of interrogations happening at school, because they're able to take advantage of the school policies to add more pressure on the child to talk and deprive the child of more, of less freedom of movement than they have even just by virtue of being at school. So that factors, yes, it's a school issue, but it's also an age issue. Because again, if the vice principal had been questioned at the school, he wouldn't be operating under that same age restriction that J.D.B. was. And so hopefully the court is going to take that into account and realize that the reasonable person must really be the person in the suspect's position. And in this case, that suspect is a child.
Hannah, did you want to add something?
I was just going to add that the other reason that maybe we're unrealistically hopeful about Roberts was that Roberts had concurred in Graham and Roper, the two cases, and he didn't like the broad rule of the majority, the categorical rule, but did recognize that kids were different. The other reason perhaps on this streaming.
It's always so intriguing to hear the backstory behind any important litigation. So thanks very much to Barbara Blackman for being here. Also to our own Hannah Demerit, who worked on the case, has provided tons of information about it, is a Duke grad, and some of you may have her as a teacher because she is teaching here now. So thanks, Hannah, too. So on the prediction stuff, the unrealistically hopeful Chief Justice Roberts. Let me just say this about the Chief Justice Roberts issue. If I were one of Chief Justice Roberts' children and I were being questioned by law enforcement, I would strongly favor the rule about having a parent in the room when that happens. Without question, he has a perspective on that. I don't know whether that's going to translate doctrinally, but I do think it's always interesting, especially with regard to the human behavior that is at issue in criminal procedure cases, to think about the justice's own experiences and reference points. So I'm intrigued by that notion. I think Justice Kennedy is the one to watch. He would be anyway, because he voted 92% with the majority in the last term of the court. So it's, the odds are on Justice Kennedy's vote in any case. He is the author of the Alvarado decision, holding that a 17-and-a-half-year-old who voluntarily went to the police station and was questioned there, which is a quite different circumstance from what we confront here, that factor did not play into the custody determination. Procedurally, that case is different. It's a habeas case. There are some reasons not to view it as predictive. But because he authored that opinion, hasn't really shown his hand with respect to the argument in this case, and is certain to be in the majority. I think you have your eye on the right justice. But I'm often wrong when I try to read the tea leaves of the Supreme Court, so I won't actually try to do that. And instead, I want to suggest some context for this. Two sort of doctrinal points about it that are maybe a little more meta. It's always fun to hear advocates talk about their own cases. They're so intricately bound up with the facts, they almost can't, and you can't you can't think about them in any other terms anymore. So I'm going to step back a little bit and talk about doctrinally, and then two theoretical points that I think are even more important. First, this issue about objective versus subjective considerations. I'm not sure I agree that everyone has decided that age is an objective factor.
I was just saying the parties.
Okay.
The parties are in agreement.
I don't know that the court is ready to go there. It's a number, so it's quantitative. I mean, it has many objective characteristics. It's readily ascertainable as a fact. And so it does look like an objective fact. But the question is, in this context, is it more like language? Like if you didn't speak English and were given your Miranda warnings in the wrong language, that objectively you were not warned. So is it more like language, or is it more like culture? Did you immigrate from a country where law enforcement is particularly frightening and therefore have feelings about your encounters with law enforcement that might lead to greater experience of coercion? The court wouldn't take that into account in the custody determination. That's culture. But they would take the language thing. And which is age? Is it more about the psychological experience of the interrogation, or is it more about an objective fact that's readily ascertainable? So that's an intriguing notion that hopefully we'll get some clarity on, regardless of how the case comes out. And the second point is about whose perspective matters more. And this feeds into one of the objections to your argument has been, well, how, on the ground, embarking on an interrogation, is the officer always supposed to know whether it's a 17-year-old or an 18-year-old, or is it a 15-year-old? And that's an administrability argument, common in criminal procedure. But really, in making that argument, the government's trying to have it both ways, because the officer's perspective isn't supposed to matter at all with regard to the custody determination. What matters is how the suspect is experiencing it. Interestingly, Justice Breyer in the Alvarado decision actually suggested this is one of those cases in which we need to look at both, and we need to account for how the suspect is experiencing it and what the officer knows at the time. We have not seen that sort of blend before on the custody side. We have seen it on the interrogation side, where there is a rule that if officers know that a suspect is peculiarly susceptible to a certain kind of interrogation because of their religious beliefs, because of their psychiatric state, and they engage in that sort of interrogation, that will be interrogation, even if it wouldn't look like questioning if posed to some other suspect. And so that implicates the officer's knowledge. That's a blend of those two different perspectives. But in the custody context, it's kind of asking to have it both ways if you make administrability arguments about how officers are supposed to be able to tell. What we're supposed to focus on and what we're supposed to care about doctrinally with respect to the definition of custody is how the suspect experiences it. And we should be able to determine how a reasonable 13-year-old or 15-year-old or 17-year-old would experience such a thing, just like we can make some determinations about how reasonable people feel if officers brandish weapons. There's no question that some people aren't very scared of weapons, and there's, some people will faint dead away at the sight of one. But we don't account for that. We just say reasonable people are scared this much of weapons, and we factor that into the calculus. Or they react this strongly to someone flashing a badge and that kind of show of authority. And so a court has made those kinds of determinations. How much more comfortable are people in their own homes versus their workplaces versus the police station? And we account for that. Using this reasonable person, there's going to be a lot of variance. There are 14 and 15-year-olds who are much, much savvier about law enforcement than reasonable 50-year-olds. But that's not the calculus that we would be making. We would be just asking the reasonable child of this age. So from the administrability standpoint, I think there are strong arguments in your favor. I don't know if they'll be persuasive for the two theoretical reasons that I want to introduce. I want to situate the case. So I agree with you completely. I was stunned when the court granted cert in this case. And you had to think about it for a long time. They have been granting cert in a lot of Miranda cases. The defense has lost every single one of those cases. 2 terms ago, they were granting cert in a lot of Fourth Amendment cases, and the defense lost all of those cases. They're interested in Miranda, but they're interested in it in a very particular way. So one should be alert to that as well. Were you to win, it would be a rare victory. And it's kind of perilous on the other side. So that has a particular history. Many of you know this already, but Miranda was decided in 1966, and it is impossible to convey to students today how significant it was at the time. It is so culturally ingrained now that we don't recognize its import. But when it was decided, it was viewed as completely revolutionary. It was distrusted, it was feared. It was the focal point of the political campaigns in the early 70s, the Nixon and Wallace campaigns. It was the central target for the backlash against the Warren Court. It is easily, at the time of its decision, the most unpopular criminal procedure decision ever. It's also probably the best known criminal procedure decision, in part for that reason. So it was regarded as this radical step, and the fear was it'll have a detrimental impact on police investigative practices, on confessions, and on the conviction rates for, in some cases, serious crimes. Over time, in part because 80% of all suspects and 90% of juveniles waive their Miranda rights and go ahead and answer against all advice they've ever heard, law enforcement questions anyway. With that high of a waiver rate, it's not that robust of a right. And empirically, for that and other reasons, over time it's become clear it hasn't had much of an impact on investigations, interrogation techniques, the rate of confessions, or the rate of conviction in any significant way. So some of those fears have fallen away, although there are interesting empirical studies that make claims on the other side. At the same time, in the last 45 years, it's become deeply familiar to us. And it's become both a law enforcement standby and a cultural script, a pop cultural script. People who know nothing whatsoever about law enforcement do know, by and large, that they have the right to remain silent. It's 4 elements. The right to remain silent, that if they talk, it can be used against them, that they can consult with a lawyer if they want to, and that if they can't afford a lawyer, one will be appointed for them. Those are the 4 essential ingredients of the Miranda warnings. This has created a problem for Miranda's detractors, and it's generated what I would call cultural stare decisis. In 2000, the Supreme Court had an opportunity to overturn Miranda altogether in the Dickerson case. And Chief Justice Rehnquist, who has been a critic of Miranda, authored an opinion declining to overrule it, in part because of old school stare decisis, which is even if current courts don't agree with prior courts' decisions, they don't overturn them so long as they are otherwise sound. But in part, and overtly, he mentions this sort of popular cultural stare decisis, which is it's an entitlement now. People understand that it exists. Or in other words, popular opinion has caught up with where the warrant court was in the late 60s with respect to this issue. So as a result, the project for the many, many people who disagree with Miranda, both doctrinally and theoretically, has been an accretive one. It's been a process of cutting back on it step by step and piece by piece and not confronting it head on. This is the same thing that's happened in the Fourth Amendment context. Much of the original doctrine stands, but the exclusionary rule is less and less robust as officers who act in good faith or make honest mistakes don't have the evidence they find unconstitutionally excluded. It's not a particularly strong right if there's no remedy. And the Rehnquist and Roberts courts have been shortening the scope of those remedies. So in the Fifth Amendment context, it looks like this. And I'll conclude with this because I know it's settled. So it exists in theory, but not as a point of descriptive reality. If not very many people are held to be in custody, which is one of its elements, so this is yet another case where if you define custody so that a very large universe of people who are being interrogated aren't in custody, then Miranda doesn't have a lot of force because it's not applying to a lot of people. If you conclude, as the court did in the last term, that even if you are in custody and you are being interrogated, you can waive your Miranda rights merely by answering questions, then the right can be, and this is the Burgess versus Tompkins case, we just talked about this in my criminal procedure class, if you can waive your rights so readily, then having it isn't all that meaningful. And if you can find broad exceptions to Miranda, as the court has increasingly done, for example, for public safety reasons. Maybe someone is in custody, maybe they're being interrogated, maybe they haven't waived their rights, but nonetheless forget about Miranda because it's really important to law enforcement to ask the questions that they're asking. That also means that it applies in still fewer cases. If you are entitled to your Miranda rights and you're in custody, you're being interrogated, and you haven't waived, and there's no public safety exception, but the warnings don't have to be given to you in a way that you would necessarily understand. If there's no particular script, this is the Florida versus Powell 7-2 decision from the last term, where a suspect was told that they had these rights sort of before questioning, but it was suggested that maybe once the questioning started, too late to consult with an attorney. The court said in that case the form of the warnings is a little bit variable and flexible, and they can be given using different scripts. So that might curtail it a little bit. And finally, if the court finds, as it has in the Siebert case, and that even if there is a Miranda violation, law enforcement can still introduce the physical evidence that it finds as a result of a coerced confession. So a murderer confesses, says where the murder weapon is, and let's add the body too, where the body is. Okay, you can't use the confession if it's a violation of Miranda, because that's a coerced statement, but you can introduce the body and the weapon that the police go and find afterwards. Miranda doesn't bear fruit in criminal procedure terms. So little by little, over decades, in all of those decisions, increasingly in the most recent terms, the court is saying, fine, have your Miranda. But it's not going to mean a whole lot. It's not going to exist as a point of descriptive reality. So this case might be in that vein.
Yeah, I mean, I agree with you completely, but I think because of the statutes that are out there specifically addressing children, if we can get the finding of custody, it's going to make a big difference. Because so many things in the juvenile system are turning off of that custody determination. But I agree with you that Miranda practically does not exist anymore.
Here's the other part of the trick bag. So even if you win, it's problematic. Because Justice Justice Alito shot a little bit across the bow in Yarborough when he said, if you begin to introduce subjective factors, and again, it's controversial whether age is subjective or objective, into Miranda, then the whole justification for Miranda doesn't exist anymore. Because the idea of Miranda is that if you engage in a totality of the circumstances, subjective plus objective analysis, like you do in the due process context, if you're trying to figure out if something is voluntary, if it's coerced, if it's actually coerced, that the idea of Miranda was we need brighter lines, we need clearer rules for law enforcement, we need to recognize that every context of custodial interrogation is inherently coercive. Justice Alito has said in another context, there's no reason to have Miranda if we interject subjective considerations. So the other problem is you win, and then actually it isn't accretive anymore. The justification for Miranda itself completely falls away. So either way, you have yourself a tricky case.
Well, thank you very much. So we're gonna have some questions. I'm gonna ask one because I've just been on my mind since you guys were mentioning the Roper and the Graham cases and Justice Kennedy being the sort of the key vote here, which seems to me absolutely right. But I'm wondering, I don't have Roper in front of me, so I could be wrong about this, but as I recall, the reasoning in that case, which again was the Eighth Amendment context, was that juveniles should be treated differently because they have impulse control issues and that they're redeemable even after they've committed a horrible crime. And neither of those necessarily seems to track this question. So that maybe juveniles are different for those reasons, but those aren't reasons that necessarily apply here. Maybe there was something also in there about them being impressionable, and maybe that matters.
They talked about how their brain development lags behind that of an adult, which obviously affects their judgment and understanding, that they fall more prey to outside influences and coercive situations. So there was some stuff in there that's directly transferable, I think, into the Fifth Amendment context.
So I saw Matt.
Barbara, thanks for
Yes.
This is great. I wanted to ask you kind of a more general question aside from the J.D.B. case. Given the kind of grim picture for Miranda rights and for the exclusion rule that Professor Griffin just described, I've been wondering, because I'm in her investigations class this semester, what's the kind of strategic approach, if there really is one at this point, for folks working in defense appellate shops, knowing that there's the sort of Damocles hanging over their head of a Supreme Court that's very much angling in a particular direction on those particular rights of criminal defendants. Is there
Oppose
a
cert.
Yes. Hope that it's not your name on that opinion.
Defensive cert denials.
But I mean, even when you go to state Supreme Courts, is there a way that you're kind of trying to hedge the argument to try to avoid a grant of cert, or is there a way that you're trying to show state Supreme Courts, look, you'll be safe if you hold this way because the court has already resolved this and they won't grant cert? Does it affect
I think you're just still
decision-making, or-
going full bore.
It's a hard.
Yeah.
One of the reasons that's a very hard question, and this is I'm speaking a little bit out of turn here because I've not been involved in a lot of Supreme Court cases but one that was a criminal case called Herring, where the question was, it's your client. You need to make the argument for your client, right? Too bad. I mean, if it hurts the rest of the defense world, right? But your interests and your commitments are to that person. In criminal cases, this does happen a lot. It's not like, I mean, civil rights cases, this happens a little bit as well, but impact litigation is just really, those questions are really difficult. This is a way of just rephrasing how hard your question is, not answering it, obviously. I don't know if there's an answer to it, if there's some
There
sort
isn't
of
an answer.
coordination issue here. But.
Well, we did have some disagreements with some of the amicus
Oh,
just
yeah.
for that issue. We were like,
Yes.
wait, we have a client. This
Right.
is not just an issue case. There's a
Right.
person here that we represent and we have duties.
Because it is hard to tell J.D.B., sorry, you'd have to stick with this.
Right.
It's a great question.
Yeah.
So that's a question over here.
One thing about the idea that the police won't be able to administer this properly or that it'll make it too difficult, it seems to me like a lot of those issues are solved by the fact that it is an objective standard, and then just inherently the fact that it's an objective standard means that police won't be expected to kind of guess how age is affecting this particular person or anything like that. You have to know that the person is young, and that's built into the test. One thing I thought was interesting in the oral arguments was when Justice Alito was saying that he wouldn't know how he would make these determinations as a trial judge, and actually taking into account how trial judges, like this is one too many factors for trial courts to consider. Do you think that logically could work into the opinion ultimately? Do you think there's any way to?
I mean, I just didn't think that argument held water because state courts have been doing it for decades. So clearly they're able to do this. I mean, I just didn't find that to be a convincing reason.
I wonder if I can just build on that one really quickly, because I was wondering, to your last point, Lisa, about if maybe what the court is concerned about, because I picked up the same theme in oral argument, which is that it's not so much an anti-Miranda agenda in this particular case as it is just almost a rule standards kind of a thing. They just don't like mushy, and it sounds mushy, because we're not saying that people under 18 can't ever be, like Roper and Graham are at least bright line rules. You just can't execute anybody who's committed a crime under this age. But what we'd be asking for here is sort of a multifactorial.
Right. I mean, but one problem is custody itself is so mushy. I mean, you can have cases with identical facts coming out different ways. I mean, that's just how it is. And I'm sure that the Supreme Court thinking, "Oy, these are going to get even mushier, and we're going to have even more contradictory opinions coming out." We can't stand that thought. But, that's what's going to happen. When you have individual judges making decisions, people weight things differently. They're the ones who saw the witnesses testify. So, there's all kind of backstories that could be involved in why a trial judge rules the way he does, and you end up with this standard that's not easy to apply. But, in these cases, the police officers know they're dealing with children. I mean, the age of a suspect is such a critical piece of information. And, they're taught how to interrogate children, what kind of tricks work with children. And so with police officers taking this into account, it just seems fundamentally unfair to me that the trial court isn't allowed to take it into account to see the results of, what the police officers are doing.
I mean, take things into account like whether parents are present.
Yeah.
And again, for some children, having their parents present, it makes them more likely to confess. For some children, having their parents present, they feel like someone's on their team and they're protected, and they can stand up to law enforcement more readily. They're less likely to confess. And there's no answer to which it is. And it's the same with age. As being 13 or 14 or 15 inherently, I think the court is a little afraid of a categorical argument that all juveniles being interrogated are subject to coercion or necessarily in custody. I think they would not. They want it. At best, they would accept it as one of 20 relevant objective factors if it's an objective one. But it's like all other, even objective factors, as we've talked about already, they don't cut the same way for every person. But what makes them easy to apply is you don't imagine how it affects the individual person. You imagine how it affects the reasonable person, just like you do with similar concepts in tort law and other settings.
Chris?
So I'm not sure if it's actually, because my understanding from what Professor Blocher said and what from the question presented is the issue is age drawn broadly, not the question of majority versus minority. And so in that context, I guess, first, is that correct? Second, are there contexts if age is really the dispositive factor, do you think that anyone other than juveniles might be affected by the introduction of that analysis? If so, how, and is that at all something that you think comes up? Because I could see there being cases outside of the juvenile context if we're actually taking age.
Someone really elderly.
Writ broadly.
Right.
Is that something that came up? Is that something that you think the case might end up addressing? Or do you think it's more this is a child, this is an adult, and that's the line?
I think there was a fault with our cert question. Because we used the word age and we should have used the word youth. And so I think the court, if it wanted to, could look at the other end of the spectrum. Because obviously if you've got very elderly people who might be suffering from dementia or something, that could factor in also. So that was our fault. But we tried from that point on to just talk youth, to make it clear that we were talking about majority versus minority. But I do think, the question of the elderly, I think, did come up in the oral argument, it seems to me. So, I think it's something that's on their mind about whether they would be looking at other age groups as well.
Boston?
Thank you very much for coming.
Sure.
I'm actually in a writing class right now where we're writing fake Supreme Court opinions, like a clerkship type class. Because I'm very sympathetic to your facts, trying to write a majority opinion, pretend majority opinion in favor of your case. And I'm having trouble.
Well, I don't see why.
And the thing that's really getting me is this voluntariness issue that was raised in the respondent briefs. This idea that, yes, age or youth is important to recognize, but the place that it should be recognized is voluntariness and not custody. That seems pretty logical to me, that this is an egregious thing, but it should have been appealed as a voluntariness issue, not a custody issue. Could you speak to
Sure.
sort of let everyone else know what the heck that's about?
Okay. Voluntariness is a due process concept, and it focuses on whether the will of the actual person involved was overborne. It is an extremely difficult test to meet. It usually requires, physical coercion or real threatening behavior on the part of the police, like interrogating somebody for 36 hours without food or water and not letting the lawyer in to see them. I mean, the facts have to just be piled on to try to win voluntariness. And age is something that's always been in a voluntariness claim. One reason why Miranda was developed was that voluntariness was so tough to win that nobody ever won it, and confessions that really were coerced but couldn't meet that test were coming into evidence. And so the Supreme Court kind of made this shorthand test of Miranda to say, if this thing doesn't happen, we're not letting it in, and we think it's going to catch some of these coerced confessions that are making it through the voluntariness inquiry. But anyway, to sort of address your question directly, I think one could say that about any circumstance. You could just say, oh, it's too difficult to figure out the closed door, open door. It's too difficult to figure out what matters if there's 6 officers versus 4. We'll throw them all into voluntariness. And eventually you could have, the custody being one thing, which is, was he in handcuffs, and everything else in voluntariness. So I don't think that that's really a solution to this problem. I think that the Supreme Court's main problem is the language it used in Stansbury, which is all objective circumstances must be considered. And if everyone agrees that age is objective, which it is, it is, if anything else, it is objective. Then what do you do? Because there's Stansbury saying all objective circumstances. So are they going to say, well, all objective circumstances except for age? Or are they going to say, age is objective, however, we didn't mean it really as that kind of objective? That's their problem, is that language in Stansbury. And so they're going to have to decide, did they really mean it when they said all objective circumstances, because we're clearly dealing with something objective, or are they going to exempt it out? And so if I was writing your paper, I would just say that's what they said. They said all objective. The parties are in agreement it's objective. You look it up in the dictionary, it's an objective thing.
Hasn't the court also said that it's very hard to win a voluntariness claim without a Miranda violation first?
Right.
Yeah.
Karen and then Lee.
Clearly this whole panel of this case seems to be focused on age, but it seems to me under these facts, it could be even sidestepped in that if you're looking at location and situation, it seems a reasonable adult who is in a location where they are required to stop and speak to authority figures and you essentially need written permission to go to the bathroom would feel that they were in custody in this situation.
Very problematic because of Maryland versus Schatzer. So if there's a break in custody when someone who's being questioned by law enforcement goes back to general prison population and is very much in a situation where you need written permission to do everything that you do all day long, and the court has said, well, that's true, but the coercion isn't coming from the interrogators. That's your reality. That happens to be and it's the reality of a 13-year-old that they're in middle school. So I'm not sure how you disaggregate those two situations.
Lee.
So even if you get what you want, is there any value really in Mirandizing children? Are they going to understand sort of those rote warnings? And I think a lot of times it's just going to scare the crap out of them.
Well, I think that would be the next area of litigation. Some people, such as the ABA, have endorsed simplified Miranda warnings, and I think there would be a push to make that a constitutional requirement, that they come up with some kind of a warning system that a child could actually understand. But I think the major benefit goes back to these state statutes requiring parental notification and to bring the parents into the juvenile justice system to protect their children.
We could have a simple warning like, it's a really bad idea to talk to us until you've consulted a lawyer. That would be a good, right? That's the warning everyone should get, but it's not, kids would understand that, I think. But
You really shouldn't talk to us, but if you insist.
yeah, if it'll make you feel better.
Other hand back there.
I have a question about Justice O'Connor's concurrence in Alvarado. When she said that age didn't matter in this case, and didn't make it unreasonable, but she could see a case where it did matter. Is she then saying that it is a relevant factor, that if you have to consider all of the circumstances, if it could matter in some case, it has to be considered in all cases, and just not considering? I don't understand how she can square it by saying that it wasn't used in this case, and that was fine, but sometimes it's going to matter, so does that mean you have to consider it all the time?
Speak to that, or you can.
No, you go.
So she was not a big fan of the categorical, and frequently wrote opinions along the lines of her opinion in that case, acknowledging that there were factual scenarios the court had yet to confront that they should not dismiss out of hand. So to her, in that case, a 17-year-old who's voluntarily gone to the police station, has parents, is not being coerced in a way that the court should be concerned with, particularly given the procedural posture of the habeas case. But there are many, many, many concurrences by Justice O'Connor where she made exactly this move, which is to say another day will come when there is a 13-year-old who is being questioned in a closed room, in a frightening environment, confronted by numerous authority figures, without parents present, and she might want to go down that road. So I think she was just hedging a little bit against the future case, and I think that if she were on the court, that you would at least stand a better chance.
Any other questions? I'll end with one. Barbara, I wonder if you could just tell us sort of more generally about the experience of arguing at the court. I think this was the first one.
This was the first one. I was stunned by the level of uncivility. That's a word. And there was an article in the New York Times a couple of days ago entitled "Nice Argument, Counsel, but Listen to What I Have to Say." And it was about the current tone of arguments in the United States Supreme Court. I mean, they interrupt beyond constantly and punt questions back and forth to each other, to their voting bloc, so that they're trying to take up the majority of the time. And
Justice Thomas is very polite.
yes, he was very polite. He was very polite. Actually, yes. Swish. I mean, what Justice Thomas has said is that he finds the arguments very unsettling, that the court is inviting lawyers to come talk to them, and then they don't even let the lawyers get a word in edgewise, and he chooses not to be a part of that process. And I say, hats off to you. He was clearly listening, because I could watch his little eyebrows shoot up and down.
He was reading a book.
Yeah. So he was paying attention, but he just was not verbal. But it was an interesting experience. Everyone makes their positions very clear, very clear.
You think that? Wait till we
Yeah,
be surprised.
Yeah, we'll
when
see.
Kennedy
Yes.
writes the opinion and
Kennedy.
it comes out the way you want, you'll have to eat some of those words.
I don't know.
Many an advocate has been wrong
Yeah.
about the experience in terms of what it
Yeah.
augured for their outcome.
Yeah, he was not as active as I thought he was going to be.
Well, I think that's
Yeah,
actually good for
I
you.
thought it was good, and he seemed kind of perplexed. I mean, he did. He had like this quizzical expression on his face.
That's positive.
Yeah.
I think he has 3
Yeah, and that was it.
short ones.
But I wasn't sure. They were so argumentative that I was getting really angry. And I didn't know how argumentative to be back at them because that's not my normal style. But I was getting so angry. And I mean, at one point, Justice Sotomayor asked me this question that was just legally wrong about, if someone stopped on the street and blah, 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 blah. And what she was describing was a Terry stop, which is not custody for Fifth Amendment purposes. So the premise of the question didn't make any sense. And so, when she finished her question, I said, well, that's a Terry stop and blah, blah, blah. So we're not talking custody. And she was very insistent that she was talking custody. And I was sitting there going, well, do I come back at her again? Because the premise of the question is just off. And I didn't want to be seen as conceding anything, but the question was off. And I found myself in that situation several times in that argument where the question just legally wasn't making sense. And so it was kind of difficult, you know, when you're standing there thinking on your feet, trying to figure out what to do with those questions, because it wasn't that they were harmful, you know, based on the law that should be applying. They were just so out of left field, they didn't have anything to do with what the question was. So I found that a little tough to handle.
Well, it's just that we demonstrate our civility by thanking Professor Griffin and
Melvin Myers
not long after.
and Hamdan V. Rumfeld while still at Yale. So thank you all, and I will now hand the floor to Professor Burke for a brief introduction to the case.
Thank you very much, Chair. Thanks to all of you guys for being here. I'm just going to say a few very quick words about the facts and legal issues, and then turn it over to the people who actually know something about the facts and legal issues on the case. So, pitch most general. Questions raised here is whether the minor's age must be taken into account in determining whether he is in custody. And that is an important question because people who are in custody need their Miranda rights, and if they're not, then the evidence coming out of whatever interrogation is going on may be suppressed. And so our question, because determining one's in custody, turns on the question whether a reasonable person would think that they're free to leave the interrogation that's going on. And that is a hard case, but it's particularly hard when the person who's being interrogated is 13 years old, and J.D.B was at the time that this interrogation happened. And the facts of the case, I can correct me if I'm getting these wrong, but I think the application of the legal issue pretty well. So, in 2005, a guy named Joseph D. Sando, who was a juvenile crime investigator in Chapel Hill, was looking into a series of home break-ins. And got evidence that J.D.B, who was 13-year-old education student at Smith Middle School in Chapel Hill, somehow involved. So went to school, to Smith Middle School, while J.D.B was in class, and talked to school administrators there. I think he was accompanied by another police officer. We have evidence linking this student who's currently in crimes, and we'd like to talk to him. So they take J.D.B's class, take him to a conference room where he discusses, or he's indicated his question, D. Sanzo, another police officer, and his principal, maybe another school administrator. At no point is he told that he can leave, at least not yet. His grandmother, his guardian, is not informed. He is not Miranda. He's not ready to return silent. The stuff we know. And the police officers start asking just some general questions, and then they start asking specifically about the break-ins, and they tell him they found a stolen digital camera, which was connected to one of these break-ins. And his principal tells him that he wanted him to do the right, and that the truth always comes out in the end. He starts to get nervous. He asks if return things will still be in trouble, and they tell him, well, that will help, but you'll need to make things right. And soon after that, he did not have to talk to her again, just warning, say that he could get up and leave, but that the officer wanted him to listen to what the officer did. At that point, apparently J.D.B. broke down